This is Senate Judiciary. It is finally Friday, the 25th of February, 2022. And we have a number of witnesses here this morning to discuss S-140. And because Senator Bruce, who was going to be with us, got stuck in Atlanta last night, on his way to New Mexico. And quite frankly, I didn't think that was a direct line from Burlington to New Mexico, but he won't be with us. So I'm not able to vote on the bill today. We're going to wait until a week from Tuesday. But we can take testimony and some issues have arisen. And Eric, would you just remind us of what some of the issue that came up was, the issue, somebody helped me with my jacket. The issue that came up, could you remind us of the issue that arose?
Yes.
And why Sheriff Marcoux, Commissioner Demi, and others are here.
Sure.
Demo, Commissioner, I flubbed it again.
Hi, good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, here to talk a little bit with the committee about S-140. It's an act relating to civil arrests at courthouses. And as Senator Sears mentioned, there was discussion at the last meeting when the committee discussed this bill that seemed to center around a concern that the committee had regarding the liability portion of the bill. You remember with the bill, on the one hand, the bill prohibits civil arrests at courthouses. So an arrest effectuated for purposes of securing someone's presence at a civil proceeding, not a criminal, but a civil one. But there's another portion of the bill that provides a private right of action, liability, so that if someone is arrested in violation of the statute, they can bring a lawsuit for damages against the person who committed the arrest or a person who, quote, assisted with the arrest. So I think the committee's concern was, might that inadvertently, and by inadvertently, I mean the language assisted with the arrest, might that inadvertently encompass perhaps a Department of Public Safety officer, a local law enforcement officer, Department of Corrections officer who was participating or assisting in the arrest. That was the concern I think that the committee raised. And that was the reason that we asked for input from the commissioners and from the law enforcement folks, as well as from the AG's office on that point. And I think the committee has got some input and has some witnesses to hear from on that, but that was the issue, I think, that was being discussed.
Who's representing the department? Wilder, are you representing public safety on this one?
I don't think Wilda's here. I think it's her interpreter.
Oh, okay. Well, we have Emily Carr, Aaron Jacobson, Commissioner Demmel. Why don't we start with you, Commissioner? As I know, sometimes you're asked to detain for, is it up to 48 hours?
Yeah, good morning, Senator. And good morning, committee members. For the record, this is Nick Demmel, Commissioner of the Vermont Department of Corrections. Appreciate the opportunity to get to weigh in on this piece of legislation. I think largely our concerns are in line with some of the concerns you've heard already. Our staff, in reviewing this legislation, have worked through a couple of hypotheticals that we thought could arise that could put a corrections officer, Vermont State Corrections Officer, in an uncomfortable and awkward, potentially expose them to some liability. For example, in a situation where an ICE officer were attempting to make an arrest at a courthouse, if there was a confrontation or some type of disturbance and they requested assistance, and our officer would be compelled in some ways to intervene to assist a fellow law enforcement officer, perhaps not even knowing the circumstances of that it was an ICE arrest versus some other state or federal lawful arrest. and expose themselves to that liability without even knowing that they were assisting in that specific type of arrest, which raised some concerns. I'd caveat all of the concerns that we have, though, by just saying that we struggled to find an instance in the recent past where this type of situation has arisen. And it's extremely rare, I think, for the Department of Corrections anyway, to encounter ICE agents, performing their duties. But that isn't to say that it couldn't happen. As you're well aware, much of the records are public, and planned court appearances, the dockets are published. And so if ICE or some other federal agency wanted to know when the Department of Corrections were to bring an individual that is in our custody to a civil or family court hearing, certainly they probably could do so and predict when those people were going to make appearances at the courthouses. And it would put us in a very difficult situation where that person may still be in the custody of the Department of Corrections, but is now being arrested or attempt to be arrested by federal agents, federal ICE agents. I know Commissioner Sherling from Public Safety had also voiced some additional concerns, and we'd reiterate those concerns. And my only ask is if there is some type of carve out that's created for state law enforcement officials, that we include corrections officers in that type of language. Sometimes there's a distinction there, and we want to make sure that our officers are protected from this type of exposure as well, if that's the direction you all take.
Okay, thank you. Eric, I know we've changed the remedies, but in the first remedies, a person who violates this section by executing or assisting with an arrest prohibited by section shall be subject to civil contempt. Could you put knowingly?
Yeah, absolutely.
I mean, if there was a disturbance and a corrections officer was trying to assist with the disturbance, they didn't know, that ICE was trying to help, but presumably if they knew, then they would be in violation. I don't know if that solves it.
I think that goes some way toward addressing some of the hypotheticals that the commissioner described that could unfold. That way you would, someone who was assisting in an incident that they didn't realize was.
Yeah, I was unable to print. My printers lost communication with my computer, so I was unable to print out the latest version of 140s, so I'm not sure where I'm putting it, but
actually the Colorado bill uses the word knowingly. The New York statute uses willfully. So but I think trying to get at the same concept, I think that you're talking about.
Eric, you can talk about my amendment at any point, because I think it's going right to this question.
Right. Thanks, Senator Benning. I didn't want to do that until you mentioned that.
Okay.
Yes.
Why don't
Senator... Sorry, go ahead, Senator Sears.
No, go ahead.
Well, I was just going to say that Senator Benning had the same thought and had proposed an amendment to use the word willfully and it would read a person who willfully assists in an arrest. I think would be where the word goes, but I could pull it up if you want to take a look at it.
Well, why don't we hear from Sheriff Marcoux and Aaron Jacobson and Rebecca Turner, and if there's somebody here from DPS, fine. I'm sure their concerns are similar to the sheriffs and commissioners. Sheriff, thanks for joining us this morning.
Good morning, Senator Sears and members of the committee, and thanks for having me. I'm covering for Sheriff Anderson, who is in Iceland on vacation right now.
Speaking of ice.
So probably our weather is worse here than there. So
probably.
So I'm approaching this, Senator Sears, with the in the way that addresses us as security there in the courts, which we've been working with you on for other things. I would want to make sure that we don't get caught in a similar situation where we're responding to have to help ICE or somebody, and unknowingly there becomes a fracas, and then we get involved, and then we're rolled up into that same were thought of as being a party to the arrest. So I just kind of want to study the language a little bit more. I like the knowingly. That kind of makes more sense to me than willfully, with respect, all due respect to Senator Benning, because if we're trying to intervene to keep order, that we're doing so willfully. But if we're intervening in a situation that we're thrust in, that we didn't know what the initial reason, for the intervention with the other law enforcement agencies might be. Just want to make sure we're covered, because we're trying to provide this for the security of the courts, and that's our number one concern. I don't want our people thinking that we're going to be, having to look at a civil violation or be in violation of this law.
I just want to jump in and say I would have no problem using both words, knowingly and willfully, to try to do what I can. I want to vote for this bill, but I don't want to have anybody in the state caught up in unintended consequences. So I'm hoping that we can go in a direction that makes everybody happy.
Well, that's fine either way. But let's hear from, is there anybody from DPS here? Not public service, but public safety. Okay, Rebecca or Erwin, you want to? Aaron, I mean, oh my God, why do I keep screwing it up?
Good morning, Chair
Good morning.
Steers. Don't worry about the name portion.
Well, I am. I'm embarrassed.
Well, you don't need to be.
It's my Boston accent, and I should be able to do that one easily.
Wow, I very much appreciate the Boston accent, that's for sure. Good morning to everybody. Thank you for having me back again. For the record, Aaron Jacobson from the Attorney General's office. And I would just say that that these concerns about not wanting state or local law enforcement to inadvertently get wrapped up in some kind of federal ICE arrest is also very much at what's at the heart of this bill, which is the federal commandeering of important state resources that then only serves to undermine trust in our judicial system, in our public safety system, and also, not to mention, just takes up scarce resources. So the intent of the bill is not to in some way create liability for law enforcement or court employees who are simply trying to keep our administration of justice moving forward. And so the Attorney General's office would certainly support adding language, willfully or knowingly, with whatever the legislators prefer, or both, if that makes more sense. And so, I agree that we want to make sure that the intent of this bill is really just to make sure that federal officers can't come into our courthouses, effectuate civil arrests, scare people from attending those court hearings, or somehow then just completely disrupting what our courts are trying to accomplish, which is already so difficult.
Thank you. Any questions? Rebecca, do you want to weigh in here?
Thank you, Senator Sears. Just briefly, again, for the record, Rebecca Turner from the Office of the Defender General. I don't have any objections. I think the language being proposed here this morning is fine, and I think addresses the concerns raised. I appreciate the addition of the Colorado legislation, the New York legislation into this discussion. Those bills were passed 2020, I think, maybe New York in a little bit earlier, 2019. And as legislative counsel said, there is a mens rea component to require that before there can be a violation, a willful or knowingly. has been discussed. And again, I just want to highlight that, as I previously testified, this is very much in the wheelhouse of what the courts have always been able to do. Right. This is old common law practice going back to England. The Colorado legislation references it explicitly in the introduction. I think New York's law does too, and so that no person could go in and do this civil arrest outside of their official capacities. Right. So I think that to the extent there is any concern that this opens up new liability, it's always been there, right? There, because this common law practices has existed. So I think that no objections, no concerns from the Defender General's perspective, and we continue to support this bill.
Anyone else who would like to comment on this bill? Thank you so much. Eric, maybe you could put up Senator Benning's amendment. I do have it. It's on our.
Sure. Yeah, I'll pull it up real quick. There it is right here. And you see again, this is, can everyone see it? I should ask first.
Yep.
Okay, great. The provision that it's amending is the liability provision we discussed about. Again, it's not the prohibition on civil arrest at courthouses. It's the provision that's related to whether a victim who's after the section has been violated, someone is arrested, whether someone would have a lawsuit for damages. That's what the provision is related to. And you see the language is on line 5. The new word inserted here is willfully. So a person who violates this section by willfully executing or assisting with an arrest prohibited by subsection A. So you can either have willfully executed the arrest or willfully assisted the arrest, but that word for the mens rea, as has been discussed, is added so that there's some requirement that the person either executing or assisting the arrest have done so willfully before they could be subject to either civil contempt proceedings or liable in a civil action for damages for false imprisonment.
Right.
So yeah, it's pretty straightforward and reflects what the committee's been discussing this morning.
Yep. I don't really, quite frankly, don't know if it makes a difference if it's willfully or knowingly.
Just curious, Eric, if you had both words, is there any reason, if you had both words, is there any reason that would be confusing? I mean, I look at this and I'm seeing a judge on the bench listening to arguments from both sides, and willfully is distinctive from knowingly. But
yes, I agree.
You said them both, you're covering all the bases that need to be covered.
Yeah, I think willfully is more synonymous with intentionally rather
Right.
than knowingly. So that I think there might even be a case law to that effect that willfully and knowingly willfully and intentionally are virtually the same. Whereas knowingly, I think you're right, encompasses a concept of you're knowing the facts surrounding the conduct as opposed to just doing it intentionally.
So Senator Sears, if I could amend my amendment, I would just ask that we amend it to say willfully and knowingly.
Yeah, that sounds good to me. Everybody else okay with that? I can't see Senator Nicholson.
Nitka, yes, I would like, no, I like it, the amendment, but I would like knowingly added as well.
Same here.
Okay. Well,
Should I pull the language down, Senator Sears?
Senator Marcoux, Sheriff Marcoux has a comment. Senator, Sheriff, you're muted.
Sorry. I have a question that hopefully is a helpful question, but on the section B of 3701, under the exceptions, it says an arrest pursuant to a judicially issued warrant or court order. Would you mean a state court order? Does it make sense to specify? Because if we're talking about ICE, that would be a federal, they could be there on a federal court order.
That's an interesting question. I'm not sure how that would work, whether or not the ICE agent is there. Would they be exempted under that language? That might be something that Attorney Jacobson or someone else might have better knowledge as to how that works in practice than I do.
Hi, it's Erin Jacobson. I don't know how it works in practice. I've never experienced ICE coming in with a judicial warrant of any kind. My only experience is when they've come in without a warrant, and that would be the civil arrest. So, this bill is not trying to prohibit criminal arrests or arrests with judicial warrants. I would leave it up to the committee to decide if you want to be more specific about the warrants. But again, this is really just to the bill's intent is to protect from civil arrests.
I only ask because there's going to be a training component to our deputies there for security, and I just want to make sure that I understand completely when this is done as to what the intent of the law is.
I appreciate that. And the intent is not to prohibit criminal arrests or arrests for which there is a warrant.
Thank you.
I think since this is based on New York and Colorado, correct? Am I get the right states?
Yes.
I'm comfortable with going forward with you redrafting with this and maybe sending it out to everybody, and that gives them a week to look at it, and we'll vote on it on Tuesday, whatever date Tuesday is. I think it's Tuesday the 8th, but I'm not sure.
Yeah, I can certainly do that. I can send it out today for sure.
Yeah, Tuesday the 8th. And then Senator Baruch will be here, and I'll be able to vote on the bill and his bill, and be able to hopefully report the bill.
Should I pull the screen down, Senator Sears?
Yeah, that'd be fine.
Yep.
All right. Next is, well, we're gonna move away from S-140 and move to S-127, but I wanted to make clear to everyone that we're not taking up the contents. We plan to do a strike all amendment to try to deal with Rule 74, which, for everyone who might remember, Rule 74 was part of our efforts in justice reinvestment to make some changes in the furlough system. And Rule 74 had to do with intercepts, intercepts of furloughs when someone has done something and they're going to be, I believe, more than 90 days incarcerated, and it provides for some court action. And so I was contacted by Commissioner Dummel, and I know he's been working with both the courts, the Defender General, and so I'm going to let him kind of, maybe Eric, do you have a draft of this yet? Or Ben, I'm sorry.
Yes, hi, Senator Sears, Ben Obergrowski for the Office of Legislative Counsel. I do have a draft. I'm happy to share my screen so everybody can follow
Yeah, why
along.
don't we go through the draft and then have the witnesses discuss pros and cons about it?
One moment, please. Peggy, do you mind enabling my screen share?
We should be all set.
Thank you. Everybody see my screen? Chair Sears, just from my understanding, S-127 hasn't been walked through at all yet. This would be the
No,
first
but I
time.
didn't think we were gonna do the pilot project unless people want to do the pilot project. I was planning to just strike section 1, the pilot project. Again,
Okay. Well, that can be,
but although if the department and the court want to go do a pilot project, I'm happy to do it. I was just looking for a vehicle for the Rule 74 changes.
well, in this version, I added the rule change to the pilot project, but that can easily be changed depending
Yeah,
on.
well, let's hear from the commissioner and others whether they want to do the pilot project. If they do, I'm fine with keeping that in, but I was more concerned with I felt like that was the big concern, was Rule 74. And I know there's a huge difference of opinion on Rule 74. But why don't you walk us through the whole thing then?
Okay. Well, this is a strike all amendment to the initial version of Senate Bill 127, which just included what is section 1 and also what is now section 3, the effective date portion. But section 1 discusses a pilot project that the Department of Corrections, in consultation with the court administrator, shall establish a pilot project to provide the court with a report prior to the sentencing of any defendant to a term of probation for a felony pursuant to 28 VSA section 205. The report shall be designed to assist the court in setting probation conditions and shall include the defendant's risks and needs and assessment results, mental health and substance use disorder screening results, and criminal history. This is essentially just designed to provide a report to help set the defendant's probation conditions. Subsection B, the department and the court administrator shall jointly select 2 or more units in the criminal division for participation in the pilot project established by this section. On or before December 1st, 2022, the department shall report the results of the pilot project to the Joint Legislative Committee on Justice Oversight. The report shall recommend whether the pilot project should be made permanent throughout the state. So essentially, it selects 2 courts to try it out. And to go from there, depending on the report to the Joint Legislative Committee on Justice Oversight.
I believe this was part of justice reinvestment too, as well. But Senator Nitka probably has the notes that.
Well, I can proceed on to section 2, which is the Rule 74 change. So what is now new section 2 added to S-127. This portion of the bill amends 28 VSA section 724, which concerns the terms and conditions of community supervision furlough. Essentially, what this section does is that it creates or changes the procedure in which the review to the Superior Court, or what the Superior Court would consider in its review of an appeal by an offender. So and now in subsection C, subdivision 1, there's some clarifying language added on 8 and 9 to clarify that it's community supervision furlough status for a technical violation. So it now reads, an offender whose community supervision furlough status is revoked or interrupted for 90 days or longer for a technical violation shall have the right to appeal the department's determination to the Civil Division of the Superior Court in accordance with Rule 74 of the Vermont Rules of Civil Procedure. The next portion on lines 12 through 14 have been struck out. This previously concerned a de novo review of the appeal, which basically means that the court would review the record anew without deference to the department. But it did give the court discretion to accept additional evidence to supplement the record. This is now struck out, and instead of that, it now reads on lines 14 through 19 that the notice of appeal filed pursuant to Rule 74 shall include a certification that the court has subject matter jurisdiction. The department, through the office of the Vermont Attorney General, shall file any objections to the notice of appeal within 14 days, which shall stay the filing of the record on appeal until the court issues an order on the department's objection. So this essentially clarifies that only appeals concerning technical violations are heard. And that's why the certification as to the subject matter would need to accompany the notice of appeal accompanying the Rule 74 motion. Moving on from lines 19 onto page 3, the appellant shall have the burden of proving by preponderance of the evidence that the department abused its discretion in imposing furlough, revocation, or interruption for 90 days or longer pursuant to subsection D of this section. This remains unchanged. Subdivision 2 and 3 are new additions that essentially limit the question on appeal and provides an abuse of discretion standard for the review. So it now reads that an appeal filed pursuant to this subsection shall be limited to determine whether the decision to interrupt or revoke an offender's community supervision furlough status was an abuse of discretion by the department based on the criteria set forth in subdivision D2 of this section. The length of interruption or revocation shall not be a consideration in the abuse of discretion determination. Now, abuse of discretion is sort of the highest standard of deference that the court would give to the department or an agency. And it essentially means that the court or agency totally withheld discretion or exercised it in a clearly unreasonable or untenable way. So it gives the department more deference, much more deference in its initial decision. Subdivision 3 reads that an appeal filed pursuant to this subsection shall be brought in the unit of the Superior Court in which the offender resided at the time the offender's furlough status was revoked or interrupted, or the unit in which the offender is detained after the offender's furlough status was revoked or interrupted. This essentially just means that the case can be brought either where the offender lived at the time that the furlough was interrupted, or where he or she was detained after the revocation interruption. And then the lines 13 through 15 provides a mechanism to transfer venue if it was somehow filed in a court with improper venue. So it reads, if an appeal is filed pursuant to this subsection in a unit lacking proper venue, the court on its own motion or on timely motion of a party to the appeal may transfer the appeal to a unit having proper venue. Scrolling down, subsection D defines what a technical violation is. It remains the same for subdivision 1. Subdivision 2 has a grammatical change, so it now reads that it shall be an abuse of the department's discretion to revoke furlough and interrupt furlough status for 90 days or longer for a technical violation, unless, and then there are 3 subdivisions that provide that the abuse of discretion can be considered for a longer period, and subdivision A and B. Subdivision A remains the same. Subdivision B is changed in the sense that the language that would give that would consider to the community or poses a threat to abscond or escape from furlough, that is actually changed to new subdivision C, and it now reads that the commissioner has issued a warrant for an arrest of an offender because the offender has absconded from furlough. So what this does is that rather than just sort of a determination that the offender would pose a risk to abscond or escape, it actually goes a step further, and the commissioner would have to issue a warrant because they had actually absconded from furlough. And then the section 3 is the effective date, which remains unchanged from the initial version of the bill.
I think I understand the technical violation versus a crime, but if a person is incarcerated on a DUI 3 and is not allowed to consume alcohol or drugs and is out on furlough and is caught with alcohol or drugs, it wouldn't be a crime because people, as long as the person was over 21. So if somebody's furlough is interrupted for that, that's a technical violation, correct?
I think it could be. However, and it may be better for Commissioner Demmel to answer this, but from what I understand, similar in conditions of probation, which furlough is a bit different, but if you do violate a condition of probation, that can be a separate criminal charge brought against you. I'm not as sure as far as the technical aspects of furlough compared to probation. So I think I would defer to the department.
I guess my question for the commissioner would be, is a technical violation of furlough similar to a technical violation of probation? Senator White, did you want to ask a question or comment on my question?
Yeah, I would like to actually. I think that actually putting those conditions on probation or furlough, there was a Supreme Court ruling, Albert or that something, I think that's the name, that said that because the legislature has determined that you cannot punish alcoholics for drinking or having alcohol, you cannot use that as a condition of probation or parole. And yet that ruling is violated all the time by probation and parole.
Okay.
It is put on as a condition, and I assume that it's the state's attorneys that put the conditions on, but they are violating that Supreme Court ruling. And I'm not sure how we get people to understand that.
All right, well. Okay.
Just pointing that out, that is a real problem.
Understood. Maybe I used the wrong example. If the person refuses to live where he or she is supposed to or violates curfew, that's a technical violation, correct? Not
Senator,
a crime.
Sorry, this is Commissioner Demmel. I think under either example, assuming for the sake of this argument that it was lawful to have prohibition against alcohol or drugs, in that instance, that would be a technical violation, not a non-technical violation. Drugs are a little more difficult because the aperture is bigger. So, if they were carrying around a substantial amount of cocaine, that might constitute a new crime if it was charged. But what we're talking about here are, I think, conditions that don't rise to the level of a new criminal charge, and specifically would be, a prohibition against travel somewhere, or not like your second example, not living in the residence that was approved. Something along those lines would be a technical violation. Whereas if you were on a DUI 3 charge, were released on furlough, went out into the community, and then were arrested for DUI 4, that would be a non-technical, that would be a new criminal charge.
Okay.
And that would be the distinction there.
All right. And I'm assuming that a lot of these are domestic violence cases where they are not allowed to visit the person whom they are convicted of assaulting, for example, and they do, and that results in results in a furlough interrupt.
That could be one example. Not participating, not showing up to your meetings with probation and parole officers. we have many instances where individuals will skip numerous meetings in a row, multiple attempts by a probation officer to make contact and rearrange scheduling. And there's just persistent noncompliance with the rules set out. That would be an example of a technical violation. Certainly over, interstate travel, that is usually one of the conditions where you're not allowed to leave the state of Vermont when on furlough release. And we have many individuals who will leave either, to a neighboring state, New York, Massachusetts, New Hampshire, or in some instances will travel great distances, anytime you'd leave the state,
So-
that would be a technical violation as well.
Can you help us to understand what problem this is trying to solve? Section 2, I mean, I think section 1 is fairly clear. And do you want to do the pilot project still?
Yeah, if we want to touch just quickly on the pilot project, I'd be happy to do that. I think it's the preference of the department at this point not to move forward on the pilot project, but that's something that we'd be happy to discuss further with you.
Go ahead.
So as it relates to the Rule 74 violations, to clarify, I think there's probably only one area within the proposed language that all three of the witnesses agree on here, and that's the venue change. And that's an area we all identified as something ripe for reconsideration. What we were seeing is that many, if not all of the cases were being stacked up in Washington County, and it was overburdening the courts. And so that was a consideration that the courts brought and said was a huge burden for them. Certainly, we don't have any preference on Washington County being the venue of choice, and would be happy to spread this around to relieve the burden on the courts. And then I think also Prisoners' Rights Office had some concerns about where the venue was. And I think what we captured here was agreeable to all the parties. I don't want to speak for anybody else, and certainly they'll have the opportunity here too. The bigger issues that the department is facing with Rule 74 are we're seeing numerous instances where a court will review the department's decision, say that we did not in fact violate our discretion in issuing the decision, and then institute a new conclusion, a new set of a new timeline for the revocation sentence or other conditions that change the decision that the department made. So on the one hand, the court is reviewing whether we violated our discretion, and then in practice, they're finding that we often haven't violated our discretion, but are changing the outcome. And so I think this creates an odd space in the law. And I think the de novo review language in particular basically enables two separate duplicative processes where the Department of Corrections goes through an entire process that we worked very closely with the council and state governments to craft and meet the national best practices on this, reach a conclusion. It is then appealed to the courts, and that process starts all the way over, and the court can bring in new information, can review the entire record, and then reach a totally separate conclusion. And so to remedy that, we propose some of this language that was laid out today. I think at its most basic level, the legislature in instituting furlough wanted to give the Department of Corrections an opportunity to be able to release individuals from custody where we thought that community supervision was sufficient and that they could be properly supervised in the community. And so that discretion was given to the department, separate from probation and parole. Then in instituting Rule 74, the way that it's currently written, that discretion is taken back away from the department and handed to the courts. And so we have a process that was designed one way, but is now in practice being used a different way. And I think Judge Zone is probably actually much a better position to speak to the utility of the de novo review versus some other standard here. But certainly it was creating a lot of challenge for the Department of Corrections. And we have seen fairly consistently that we are making decisions that are being overruled by the courts, but not a violation of our discretion at the same time, which puts us in a kind of an odd situation. The other huge administrative burden of Rule 74 is the requirement that we prepare and send the court the entire record as soon as an appeal is filed. And so that's what the language, I'd have to look down here to find the exact line for you. But that is where the language about filing the record and giving the Attorney General's office an opportunity to file a motion that stops the court from moving forward and determining whether, in fact, the person has met the basic standards to appeal under Rule 74 are met. And it gives the department then an opportunity with the Attorney General's office to say, yes, the standards are met here. This is an instance where we should send the record so that the court can appropriately review that record, versus having to send every record, even where we have instances that the individual appealing does not meet the very basic standards set out in Rule 74. So for example, an individual who is only interrupted for 45 days does not meet the standard here. However, those individuals still are appealing to the courts, and anytime they do, we must send the entire record forward. And so it's creating a really onerous administrative burden on the Department of Corrections, so much so that we have one person now full-time just doing Rule 74 record provision to the courts. And that's something that I think was unintended. And I think we've created some common sense language here that can resolve that and make that process more streamlined and ease that burden on us. And then I think the clarifications about what is technical and non-technical are really important to understanding the intent of the legislation. And certainly it's the department's preference that we clarify those two terms, and then, you know, ultimately we try to limit the amount of interrupts we do on technical violations and work with the individuals under our supervision to avoid those issues or remedy those issues. Non-technical violations are different because those are criminal charges that are filed, and it creates a different paradigm for us. But the intent overall, I think, of your legislation is to limit short interrupts for technical violations. And that's something the department itself took on board and recrafted our policies in this space to be really receptive to that. And we agree with that intention, that we shouldn't be interrupting people for short periods of time because of technical violations. And I think our policies are directly in line with the intent of Rule 74, but out of line with the way that it was written and how that's come out in practice with the courts. And so I think that the language that Ben went through here really does capture the needs of the department. And I think some of our other partners too. Certainly, I think this can help the courts, knowing that we probably have some disagreement with my friend and colleague from the Defender General's office, and happy to talk through some of those things as well.
Okay, why don't we hear from Judge Zone, and then Matt Valerio, if that's okay.
Good morning, Tom Zone, Chief Superior Judge. I know that Mr. Valerio has a number of topics that he would like to address on this, and I think it actually, if with the permission of the committee, if he went first, it might be helpful to focus things a little bit more before I testify.
All right, that's fine. I have no particular. Matt Valerio. We'll go to Matt Valerio first.
Hey, good
Matt?
morning.
Good morning.
Thank you. Matt Valerio, Defender General. First, let me say that I'm a little bit astounded by this being brought back only months again after the legislature passed the legislation, after 2 years of work with Justice Reinvestment 2, where Justice Reinvestment 2 found that two of the biggest feeders of the incarcerative justice system were technical violations for probation and for technical violations for furlough. And so part of what you did, if you recall, is you eliminated the ways that people can actually get on furlough, reduced that significantly, and then created this system so that the decisions that the department and that the department was making regarding revocation or interrupt of furlough could be meaningfully reviewed by the court. And that is the system that went into place. We had a 10-year period post elimination of good time during the Douglas administration, where furlough was the essentially non-discretionary purview of the Department of Corrections. And taken as a whole, if I were going to write a statute that does what this does, I would say I'm eliminating the review of furlough, because that's what this does in effect. All of the words about that in the proposal that talk about abuse of discretion, and then limit it to the record that is created in the quote unquote administrative process that the Department of Corrections has, and the like, effectively eliminates the ability of the person who is being interrupted to have any meaningful review, because such deference is given to the department that there is no meaningful review. Now, I will say that there are a couple of issues that came up in the implementation since last year. And by the way, today, right now, is the first time I've ever seen this. So nobody's ever said a word to me about this. I was actually coming in to talk about the first part, the pilot project. And just for the record, you passed the pilot project last year. And although apparently the Department of Corrections doesn't want to do it now, it's actually doing it now. And we are implementing it in Bennington County. So the pilot project is happening in Bennington County right now as we speak. So I'm not worried about the first part of it. The second part of it here, however, the thing that has happened is we got more of these appeals, these Rule 74s, than we anticipated. And one of the reasons is that in implementing furlough revocation or furlough interrupt, the Department of Corrections created a grid for what it is, what certain types of interrupts would result in, what types of, how long the interrupt would be for what type of violation. That grid did not exist previously because before that, the Department of Correction had unreviewable furlough decision-making power. And as a result of that grid, the furlough interrupts went significantly up, they didn't stay the same. So an interrupt that may have before might have been less are now more than the 90 days. And as a result, it triggers the appeal process. So we're seeing more of these than we anticipated. The reason these things are primarily filed in Washington Superior Court is because that's where all the lawyers are. That's where the Prisoner's Rights Office is. That's where the Attorney General's office is. And so that is why you see them. So whatever it gets, it does create more of a burden on the Washington Superior Court. Absolutely. If you're going to spread it all around the state, we can do that because most everything is done by video at this point. But that's really in deference to the court's resources. There's nobody, despite the fact that we have seen more of these, there's nobody in the Prisoner's Rights Office who's complaining about the number of these things that we're dealing with. And one of the things that we've seen since this law went into effect last year is that about half of the decisions of the Department of Corrections regarding furlough interrupts have been reversed. And the court has said these are not appropriate sanctions for the activity that is being violated. The Department of Corrections is not used to that because they went for 10 years without having any of their furlough interrupts be questioned at all. So if this passes as written, you're going to end up in a situation where effectively the department's decision-making process is unreviewable again. The language in there that purports to give review was always available to any inmate under Rule 75 before the process was set forth and described in Rule 74. The abuse and that's the abuse of discretion standard with a record review. Abuse of discretion with a record review, effectively, unless you are basically interrupting furlough because of somebody's religion, the color of their skin, or some other protected racial issue or category, is almost there's no way to do it. There's no way to succeed in that. And specifically, it's written into this that you can't say it's abuse of discretion based on the length of the interrupt that is being proposed. So you can't argue about how long, which is the only thing you really argue about, is does the sanction warrant the is the sanction warranted based upon the conduct? And what else is there to argue about if you have a technical violation? I mean, I have a list of these cases where you can understand very easily what the court was thinking when they say, well, the person didn't contact the their probation or parole officer on their interrupt. Meanwhile, they're literally living one block across the street. They don't have a phone, and the officer could have walked across the street and said, "Are you living here?" Yep, they could have. And the court says that's not doing due diligence on the part of the Department of Corrections. We're not going to allow a 4-year interrupt. We're going to we'll keep you at the 6 months or 8 months or whatever it was that took us to get into court to actually try the case. I understand that there are more appeals than there were before, but this basically completely undoes what Justice Reinvestment 2 did in its bill. And so, I had a call. The inkling that I had about this, that there was an issue, was just before Commissioner Demmel took office. I got a call from Jim Baker, who said, "Hey, we're getting a lot more of these than we thought we would." And he texted me a picture of a 10 or 12 appeals on his desk. And I said, "Yeah, we're getting more of these than we thought we would too." And I said, "It's because we're getting more interrupts over 90 days than we thought we'd get, because that wasn't, based on previously, we thought it would be less." Once the chart went into effect, the department created a situation where the interrupts are longer, and as a result, we end up with more appeals. But I don't think it means that the system wasn't working. I think what it shows is, if half of them are being overturned by the court, that the department was holding people more and for longer than they should have been, and we haven't been able to review it for 10 years. And now that we have, we've kind of revealed what we had always thought was an abuse of discretion for a long time, but we had no ability to challenge it. So yeah, I'm sorry if people have to work more. We have to work more too, but I don't hear my people complaining about it at all, and we haven't added people to handle it. So this is this is one of those ones, and every year I end up with one of them that makes me not happy. And this is one that makes me not happy. I'm sorry that the department doesn't want to do the pilot project, but the people who are doing it all seem fine with it.
Let me start with the pilot project. I had forgotten that it passed. That's my bad. And that's why we never took the bill up. Let me also say that I was under the impression, when the commissioner contacted me, that there had been discussions between the Department of Corrections, Judge Zone and yourself about furlough interrupts, and you were aware of the proposal here.
And this is the first time I've seen it. I had a conversation with, as I said, Commissioner Baker at the time. But this is the first time I've seen this.
Okay, I'm sorry
understand-
that I misunderstood.
I understand that there might have been, and this is Judge Zone has advised that at least regarding the venue issue, was discussed with Emily Trudeau in the Prisoners' Rights Office, but the venue issue is not the issue here. That's an irrelevance to us. The fact that it is, that these hearings, by the way, take about half an hour when you get to court, half an hour, 45 minutes. It's not a huge amount of time. And it's not a bunch of heavy lifting. It's like, honestly, in a lot of ways, it's easier than, trying a driving with your license suspended case. You just basically say what you thought the department did wrong, and the client gets to tell the story for 10 minutes or so, and that's the end of it. These cases, from our perspective, from a legal perspective, are not heavy lifting. We have to get the record, we have to review the record the same as the department does. But these are not hard to do. There are a lot of them, and I don't disagree with that. If spreading them over the state makes the courts more comfortable, that's fine. It doesn't. We don't really care which one we file in, because all the hearings are done by video. So, there doesn't matter what office you sit in when you do that. The fundamentally, though, this guts exactly what was passed in Justice Reinvestment 2, and it's going to basically every single one of these, we're going to look at it for an abuse of discretion standard, and we aren't going to bring any of them because you can't win them. Remember, at the lower levels, when the Department of Corrections is doing its reviews, the clients, the inmates, they have no lawyers. The records are what is being written down and what might be taped, although there's no requirement. And then there's a decision that's made at the case staffing level about what the interrupt's going to be. And that deliberation isn't something that is part of the record. So there's very little to review unless you have more evidence brought in. And the evidence really is, what did they do? And is the response fair? That's it. This eliminates that. So, I don't know what to say. This is a difficult kind of pill to swallow from my perspective, given how hard we worked on getting that passed in the last 2 years.
But my recollection was that if there's a 45-day intercept, that wouldn't go to the court. Why are those going to the court?
Well, because the inmates don't know what they're doing. The inmates file these things. We don't get them, and the inmates file them pro se. And there's nothing I can do about, inmates file hundreds and hundreds of lawsuits that have no value whatsoever, and it happens all the time. And whether it's Rule 74 cases or, other kind of de minimis cases, it doesn't, that happens whether it's this or something else. Maybe there should be some sort of screening process to make sure that the ones jurisdictionally under 90 days are just immediate. You don't have to produce a record. There can be like a one-page form response that says the interrupt was less than 90 days and the court has no jurisdiction over it. Check the box, certify to it, and send it back. And I agree that you don't have to go producing an entire record for anything that's under 90 days. If it's over 90 days, we got to take a look at it. we're seeing a lot more over 90 days, I guess is the other, the part that I was also talking about, a lot more than we used to, for, particularly for similar activity.
Well, that's very helpful.
Senator, would you
yeah.
mind if I clarify just a couple of points? I know Judge Zone is here to testify too, and I certainly don't want to step on his testimony.
No, I don't mind if you do, then I would give Matt an opportunity to respond.
Certainly. So I feel very badly if the Defender General feels that he was kept out of this process. That certainly wasn't the intention. As you might remember, we provided testimony with the Prisoners' Rights Office in November on this on 2 occasions, and we had a series of meetings between the Prisoners' Rights Office, the Judiciary, and the Department of Corrections to talk about this, because it was the request of the Joint Justice Oversight Committee that we put our heads together to discuss the challenges that we were facing under Rule 74. Those conversations diminished in quantity over time, but I think the one area that we were all in agreement was on the venue question. That was with the Prisoners' Rights Office and not with the Defender General specifically, so I apologize. Certainly, I think that's on me for not taking that to him personally, and I own that part of it. And so I apologize to him in this venue, and certainly I don't want anybody to feel like they're excluded from the process. One other topic that I just wanted to clarify was that Vermont case law prohibits furlough decisions from being reviewed under Rule 75. So the only place that those can be reviewed is under this Rule 74. And the grid that the Defender General was discussing is something that I think we're very proud of. It is a process that we worked very closely with the Council on State Governments to come up with, and we think it is the national best practice on how to review these. What that grid did was take out the subjectivity in our decision-making, the very thing that the Defender General was concerned about during our 10-year period where we had ultimate discretion. And instead, it gives us a parameter to look at and a scale that increases in the length of severity of the sentence imposed for the increase in severity or threat to the public that the individual possesses. And so that objectivity gives us an opportunity to say, based on just the facts, what should be the appropriate sentence here? And not the department thinks this person keeps coming up, so we're going to revoke them for 4 years. What that grid did was help us to eliminate or certainly significantly diminish the number of short interrupts for technical violations, which was, I think, the intention of this law. And instead, what the Defender General is seeing is we have many fewer of those, but the individuals who are repeatedly violating the terms of their furlough are being interrupted for longer. And each time that they come back in front of the department because they have committed another series of technical violations, they then get a longer sentence. And so it's going down that scale of either noncompliance or threat to the community. And the more and more we move down those lanes, the longer the interrupt is. And so I think what we are trying to do as a department is to get this right. And what I mean by get it right is for the individuals who just cannot comply with the standards that are put on them by the Department of Corrections or the courts, we are interrupting them for longer. And for the individuals who are committing small, minor technical violations, but certainly we think can continue to remain in the community, we are not revoking them or interrupting their furlough. And I think that is the intention of this legislation, was for those who just simply cannot comply or present a threat to the community, they need to be interrupted for longer. But for those who are compliant or have minor infractions, which don't deserve long interrupts, then let's keep them out on the street and work with them to be in the community and have a successful re-entry there. So I respectfully disagree with the Defender General that he's seeing many more longer interrupts. I think what you are seeing, and we could go through some of the fact patterns of the recent cases we've been dealing with, they're individuals who are repeatedly in violation, just will not comply with the rules that put in place, or they present a threat to the community, which is something we take very seriously. As it relates to interruptions, say that are 45 days, the Defender General is absolutely right that many of those are filed pro se by the incarcerated population. The burden, though, that we see on the department side that the Defender General's office does not experience and that the court does not experience is that for every one of those, we have to compile the entire record, send it to the court, regardless of whether they meet the standards under Rule 74. And so what this language does in this legislation is create a system where the person, even if they file pro se, would have to certify, yes, I meet the basic criteria under Rule 74. I qualify for this type of appeal. And then the Attorney General's office can file a motion that says, no, they don't, stop, and let's have a hearing about that, so that the department is not compiling all this administrative paperwork, some of which is hundreds and hundreds of pages long, and provide that to the court for each one of these instances. So that's one simple way that we can eliminate an administrative burden on the court that doesn't actually impact people who can rightfully file under this type of appeal. They would be able to certify, yes, I do meet the criteria. And in that case, the department would provide the record and the court proceedings could go forward. This is only talking about individuals who do not meet the basic criteria under this rule.
Can I just comment before we go much further? So one of the problems is people who are filing, say, 45 days rather than the 90 days. And
Correct.
They're filing it creates a lot of work for you. And as Matt said, should be just rejected out of hand because they're not, they're not eligible for that. Am I understanding that correctly?
That's correct. And in the current law, there's no mechanism for us to say, just no, we won't provide the record.
Okay, so that's one area. The second is the venue. The third I wanted to point out is one of the things that Justice Reinvestment tried to distinguish between, and I'm going to use some pretty crass terms here, those that are pains in the ass versus those who pose a real threat to public safety. And we tried to say that because somebody's a pain in the neck, I guess that would be a better term, doesn't necessarily mean they should be incarcerated, that we should find better ways to deal with them and to use our scarce resources for those who are truly a threat to themselves or others. And I don't know if we're distinguishing that. I understand how frustrating, believe me, I understand how frustrating it is to deal with someone who won't comply. It is extremely frustrating for the probation officer, in many cases for the community. But frequently those are where there's significant other types of problems that aren't being addressed. And so I don't know how to separate those two out. Then your argument, if we could separate those somehow, then your argument is much, much fewer cases. And then I guess you can argue whether the person's a threat or not, but does that make sense?
It does make sense. And I think that while I'm very proud of the grid that we've come up with, if there's areas where we need to refine it to be more responsive to that type of intention, we can do that. But what we're talking about here is the court or others supplanting their judgment for the Department of Corrections and saying that we shouldn't have the discretion to make the decision on length. And I really bristle at this idea because on the one hand, the legislature has said that furlough is a tool that we are giving to the Department of Corrections to help people get out into the community. And that's the way the department uses this tool. But where we see, for I think very good reason and well documented in our decision making, that individuals just cannot continue to be out in the community. And what we're talking about is not somebody who misses a meeting once in a while. We're talking about somebody who is released and then leaves the state and refuses to communicate with their probation officer repeatedly, or an individual that is required to go through certain programming and totally goes off the grid, refuses to participate, refuses to meet with probation officers multiple times over and over and over again. And while I recognize that there are instances where we think those individuals should not be incarcerated, we talk about the resources it takes and the situation that creates for our public, our community of non-compliant individuals who have specific needs that need to be addressed, that we put criteria in their furlough revocation to address those specific needs, and they are not complying, then we lose confidence in our ability to, ultimately the Department of Corrections is responsible for those individuals when they are in the community. And we lose control of those individuals. And then that responsibility falls back on us. Why were they not kept in control? Why were they not able to go to their programming? Why, and if they incur new criminal charges, then why did you allow that to happen? And so we really have a difficult balance here as a department. And we don't want more customers. We don't want people incarcerated. As much as we can get people into the community and have them comply and be proactive, productive in the community, that's the ultimate goal here. And we're all striving for that. But I really bristle at this idea that because the department imposed a 3-year interrupt on somebody for repeated violations and non-compliance, that the court should step in and say, you didn't abuse your discretion, but we are changing the rule, changing the outcome here. If the legislature said we may interrupt somebody for 4 years, up to 4 years, then it is within our discretion to say, then the 4-year interrupt in this case is appropriate. It is appropriate for the department to do that. If the legislature wants to say you should only be able to interrupt people for up to 2 years, that's okay. Then we will abide by those rules. But in some ways, it feels like we're given the discretion and then it's immediately drawn back from us. And so it's a really challenging place to be in. And I think if we do what the Defender General is asking and we open up the review to any part, the entire case file, and the court gets to decide all of that again for us, there is no difference between furlough and probation. So why does the state have a furlough system? That's a tool that was given to the Department of Corrections to try to increase the people out in the community. And so if we need to get rid of the furlough system because we prefer a probation system only, that's something that I think we should discuss. But if there is a decision that the department should have discretion to get people out into the community, then the review process in the courts should be, did the department do what it was supposed to and follow its own discretion there?
Well, I don't have an objection to doing away with furlough, as long as you can replace it with something. And that was part of the reason for the good time. And there was some other reasons for furlough, obviously medical furloughs, and some of those you'd keep. And that was the direction we were headed, but we kept furloughs and narrowed the number, I believe, under Justice Reinvestment too, because of the number of violations. So I will give Matt an opportunity to respond, and then we're going to take a break and figure out where to go next.
Thank you, Senator. You know, I find it remarkable that, and first of all, when you're talking about these grids that are set up, and they're always designed to promote equity, because everybody's getting treated the same way relative to the grid. But it's the exact same issue that you see with the grid as you see with sentencing guidelines. When you put in a grid, when you put in sentencing guidelines, sentences go up. Nobody sees a downward, shift when you put these kinds of tools in. And what it does is it kind of frees the department from actually exercising discretion, because all they have to do is fit it within the grid. And one of the things that we're seeing with the ones that we have approved and we're going forward with is, like I said, we're winning half of them. That is telling you something. That is telling you, that there is an unfairness that is going on. And the department for 10 years had unreviewable discretion with furlough. And this is a change, and they're not used to it. And I would be very happy to go through a list of the cases that we've won and give you the actual specifics of, you know, what the violation was and what the sanction was and why the court reduced it. You know, coming in today, I thought we were actually going to give you an update on how the pilot project was going in Bennington. So I saw Judge Zone there. I saw the commissioner. I thought we were going to talk about it and say, you know, we're making steps and we're, you know, it's actually been implemented. Judge Corsones is doing a good job, and the Department of Corrections is, everybody seems to be getting along down there. And you know, we've only done a few. That's what I thought we were going to talk about. But if you want me to be prepared totally to give you the details of the reversals that the court has made, I can easily give you, you know, one-liners on each case. One actually just popped into my box just last week, where the Prisoners' Rights Office won a Rule 74 where the Department of Corrections gave a guy a 1-year interrupt for missing a single phone check-in after faithfully for 9 months checking in on his furlough. And the court knocked it down to whatever his time served was, which ended up being 7 months. So we ended up saving a couple months because we couldn't get it into court, you know, quick enough to get it. But that's the kind of thing that we're seeing. You know, it's I would love to bring those to the committee if you're seriously considering a change, and then you can decide whether or not the Department of Corrections is appropriately exercising discretion consistent with, you know, what fairness, and whether this grid system is working the way it should. I would love to be able to bring that to you. Now that having been said, you know, what is going on, what is being proposed here, as I said before, does effectively eliminate the reviewability of these decisions. I would like to make this distinction. The case law, as Commissioner Demmel indicated, was that you couldn't bring a Rule 75 challenge based upon, this before you passed the last law. This law that we're actually working under right now, you couldn't bring a Rule 75 standard because by statute, the department's decision-making regarding furlough was unreviewable. So you couldn't bring a Rule 75. And so and Rule 75 is a abuse of discretion standard. That's why when you passed it last year under Rule 74, you set forth a specific standard and procedure by which the Department of Corrections would be judged in making decisions regarding furloughs over 90 days. And that's what Rule 74 is about. It is where there's a specific legislative procedure set forth that tells the decision makers what standard is to be used, what the criteria are for review of the department's actions. So, you know, it's a little bit into the weeds as far as the technical part of it, but if you remember last year, we spent a lot of time in the weeds arguing about that.
Yeah.
And this is what we came out with. And I thought at the end, the department wasn't arguing about it. The issue here seems to be volume, in my view. And, you know, this is I'm all for having, and I don't think the inmates don't know what they're doing when they're filing. Some of them do. Some of them are better lawyers than, you know, some of the lawyers out there, but they generally don't know what they're doing when they're filing these things. They just know they're locked up and they weren't before, and they're going to appeal. But if the department says, look, this is less than, you know, if the department says, we looked at this is less than 90 days, we certify this is less than 90-day interrupt, and that relieves us from the burden, then they can file that certification and the court can dismiss the case without production of the record. No problem. And we have no problem with venue. You know, the venue is not the issue. And if there was a lot of talk about venue, that's fine. unless they want everybody to show up in person to do these cases, and you have people traveling from Montpelier to Bennington or whatever, then that could be problematic. But as long as they're being done by video and the like, and they've even done a lot of hearings by phone before the video was available, that's fine. To me, the issue is the substance.
Right. I think you made your point. So at least we have some things we agree on. I'm going to take a 10-minute break. Senator White, if I don't take the break.
Before we
What?
take the break, somebody just came up here and gave me the news about 10 minutes ago that the governor has appointed Nancy Waples to the Supreme Court.
The governor?
Yeah, the governor appointed her to the Supreme Court.
Oh, okay. Thank you.
Yeah.
Good. Thank you. What we're going to do is take a 10-minute break, come back with Judge Zone, and then try to get to S-254 and the rewrite. I know a lot of people are in the room on S-254. We're going to try to get to that by 11. Okay, so if you want to take a break from that, be fine. I think we have two things we agree on S-127. The pilot project is working and we don't have to put that back in statute. My apologies. We're not remembering what we did last year, but I need more provision evidently. And secondly, we do agree on perhaps changing the venue and not tying up the department's hands with furlough interrupts that are less than 90 days. That correct?